Hello, this is Dustin with Jabs doing a preventive maintenance video in the courtroom of Common Pleas in Highland County, Ohio. This is Hillsborough. This is just a big old courtroom. It's a HDX with 4 wireless mics, at least. Nope, 6 wireless mics. So there's that. Judge has able to mute. Law tables are wireless boundary mics, which look like this. I don't know which mics these are. Check 1, check 2, check, check. This is pulling the overall camera. Check, 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 check. These are kind of nice. They can easily adjust the gain on them just by underneath it. This does have camera control. So we have judge witness lock. We got the left law. And we got the right law. The brightness is a little bit that is kind of weird how they have the camera set up. They're all pretty much on one wall. Didn't really notice that before. But it is what it is. Video conference, Polycom. I'm not going to call anybody. They have, it only calls their jail. System modes. It technically has a presentation.
I'll show you why a person's interrupt. Now, before we get started, to remind everybody to keep your turn off.
I don't think it's on the record because it's used as what is it called? Video conference. So it's kind of set up weird. That is all from the judge. He has a monitor, works fine. Looks like it might be stuck in camera locks. Check, 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 check. Check 1, check 2. Okay, hopefully it's gonna switch. This is another microphone. Check, 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 check. This one's labeled Judge Computer underneath. Check, 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 check. This is the witness. Witness check. Check 1, check 2, check, 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 check. This is the jury mic. It's covering the child and taped. Check 1, check 2, check, 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 check. This is the defendant's mic. Check, check, check. So it should be here. These mics are pretty good at picking up. Check, 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 check. This appears to be the prosecutor's table. Check, 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 check. And you have push to mute, hold to mute options. Check, 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 check. And this is the singing microphone. Check, 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 check. It just pulls the overall, if I remember correctly. Check, 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 check. No approach mic, technically. Check one, check two, check, 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 check. Check, check. Check one, check two, check, 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 check. Check one. Okay, hearing the system listening works great. Check, check, check. That is actually coming out of the PA too. That way they never sold any parts for this courtroom. But that's cool.
Much longer you gonna be? Okay, we're supposed to start at 10, so.
Check, check. Check, check. Removing mic. Removing mic.
Do we get a warning when this external drive is full?
Yeah, Windows will tell you that that the hard drive runs low.
Okay.
And then the recorders will also tell you if they're getting full, but you still will after that.
Mr. Weil, I think. I think that's Mr. Weil. All right, are you Stephen Charles Weil, appearing from the jail?
Sir.
Okay, this is case number 22-0129. State of Ohio versus Stephen Charles Weil. This hearing is being conducted pre-trial by Zoom, and also a hearing on the return of a capias. The defendant's attorney is William Armentrout, appearing from his office by Zoom. Appearing on behalf of the state is Assistant Prosecutor King. Defendant is charged with aggravated possession of methamphetamine, a third-degree felony. And the court had ordered a capias issued on January the 12th, which was apparently served on the 28th of January. And the basis of that was the defendant having failed to report to the probation department, as well as to turn himself in at the last hearing on a warrant that the court, I think, was from municipal court. And he had not done that. All right. So first thing we'll deal with is the trial schedule on this. See, the original trial date is, okay, we're still on schedule then. February 21st is the trial date. Okay, so this is the final pre-trial. So is discovery complete, counsel?
It is from the state, Your Honor.
I believe we filed ours, Your Honor. Your Honor, I know you say it's still on track for the 21st, but since it was placed on the inactive docket after I went through it, this is one that might be ripe for a motion to suppress, Your Honor, and I don't know if we can do that and have a trial. I've not spoken to Mr. Weil since I think he was first in jail whenever that was, before he didn't appear when he was supposed to.
All right, well, I will grant you leave to file a motion to suppress or any kind of pretrial motion until, let's see, today is the 31st, let's say Monday. Today, I say today's the 1st, yeah, I'm sorry. So Monday the 6th, and then if you do file a motion, then we will set it for hearing, and that'll probably continue the trial date since it's going to be necessary to have a hearing on that, if there is one. Has there been a written plea offer provided?
There has,
Yes, Your Honor.
That's not been, my client's not aware of it, Your Honor, because
Okay.
I haven't had contact.
Okay.
But I'll get that to him.
All right. Now we'll go to the matter of bond. The bond was set at $5,000 originally. And I'm looking to see if that had been posted in municipal court or not. Doesn't look like it. I reduced it to OR on 15th of December. Okay. All right. State what should be heard on the matter of bond.
Thank you, Your Honor. I would ask that bond be set in the amount of $5,000. I know Mr. Origine is present, so if I misstate anything, please correct me. It's my understanding that the defendant did not report to the probation. He reported when he was released on the 15th, did not report again after that, and then also managed to accumulate 2 additional warrants during that period of time. We had a pretrial hearing back on January 4th. The defendant was instructed to turn himself in, and he did not do so. So I would ask that bond be set at the $5,000. Thank you.
Mr. Armentrout?
No, I haven't had a chance to speak with my client, so I don't know if there was a reasonable explanation for why he didn't turn himself in.
Well, the court will set bond in the amount of $5,000 plus own recognizance and $171 deposit prior to release. If you do make bond, Mr. Weil, you're to report to the probation department forthwith as soon as you get out, and you are to comply with all other conditions of the pretrial order. All right. Anything further, counsel?
No.
All right, thank you. Okay, are you Jonathan Cumberland?
Yes, sir.
All right, this is case number 22 CR 41, State of Ohio versus Jonathan Cumberland, M. Cumberland. Mr. Cumberland is appearing from the jail by Zoom. His attorney is Dennis Kirk. I believe, yeah, there he is. Mr. Kirk is present. And representing the state is Assistant Prosecutor King. Defendant is charged with aggravated trafficking and aggravated possession of methamphetamine, both third-degree felonies. This is, I believe, a first pretrial, and final pretrial set for March the 8th, and trial set for March the 23rd. I see the state's provided the bill of particulars and the discovery, and you received that, Mr. Kirk?
I have received it, yes.
All right. Your discovery then will be due by the final pretrial. And do you anticipate any pretrial motions?
Not at this time.
All right. Well, if there are any, they'll be due by final pretrial. Are there any, has there been a written plea offer provided yet?
There has, and I have relayed that to my client.
Okay. All right. Are there any other matters then that need to be discussed at this time?
No, Your Honor.
No, Your Honor.
All right. Then we'll see you on your next pretrial then, Mr. Cumberland. Thank you.
Thank you.
Yes, sir.
All right. Case number 22 CR 211, State of Ohio versus James C. Howells. Is that how you pronounce your name, sir?
Yes.
All right. This hearing is being conducted by Zoom. This is a final pretrial. We have a trial date set on the 23rd. His attorney is Catherine Hapner. She's appearing from her office by Zoom. Appearing from the prosecutor's office is Mr. King. Now, is discovery complete on this case?
I believe it is, Your Honor.
I see.
It is from the state, Your Honor.
Yeah, see, now, Mr. Howells, we had to bring him back. Is it from Fayette County?
Ross County.
Ross County, okay, all right. So he's being held down there, all right. And there are no pretrial motions, is that correct?
That's correct.
All right, and where we stand regarding the case then at this point?
Your Honor, it's scheduled for trial February 23rd. I am previously scheduled in Washington Courthouse, Municipal Court, and in Pickaway County in the afternoon on that day. My understanding from Mr. Howells is that he does wish to proceed to trial.
Mm-hmm. Okay.
Now, if he's going to be here the rest of the afternoon when we finish up, I'll go out and talk to him again today.
All right.
I've got to need to see Mr. Gibson too, but as of right now, that's my understanding.
All right, well, yeah, we'll ask that Sheriff's Department hold him then until tomorrow so you can see him this afternoon. Now, what are you being held for in Ross County, Mr. Howells?
I'm serving a 6-month misdemeanor sentence for petty theft. My out date is February 28th.
Oh, okay. All right. Well, he is, we don't have any speedy trial problem here, so if you need to file a motion to continue, we can probably set that back into early March.
Okay.
And it won't be.
And I'll know by later this afternoon.
All right, okay. All right, anything else we need to discuss?
No, Your Honor.
All right.
No, Your Honor.
Thank you.
Yes.
Okay, case number 23CR001, State of Ohio versus Stephen Gibson. Mr. Gibson is appearing by Zoom from the jail. His attorney is Catherine Hapner, appearing from her office, appearing from the prosecutor's office, Assistant Prosecutor King. Mr. Gibson was indicted for one count of aggravated possession of methamphetamine, a 5th-degree felony. This is a first pretrial, I believe. And final pretrial set for the 15th, and then trial is set for March the 6th. Now, let's see, I see there's been a bill of particulars and discovery provided. You received that, Ms. Hapner?
I have, and I have given a copy of that to my client. I did receive earlier this week a plea offer that I have not yet had a chance to communicate with him, but as I'm going out to the jail later this afternoon, I will talk to him about that then.
Okay. And do you anticipate any pretrial motions?
No, Your Honor.
Okay. All right, are there any other matters discussed at this point then?
No.
No, Your Honor.
All right, your attorney will be out to see you later today, Mr. Gibson. Thank you. All right, Steinmetz? All right, are you Brenda Ann Steinmetz, appearing from the jail?
Yes, sir.
All right, this is case number 23CR008, State of Ohio versus Brenda Steinmetz. As indicated, Ms. Steinmetz is appearing from the jail. Her attorney is Sarah Barger, appearing from her office. Hearing is being conducted by Zoom. Appearing on behalf of the state is Mr. King. Defendant is indicted on a charge of aggravated possession of methamphetamine, a 5th-degree felony. This is the first pretrial. Final pretrial is set for March the 9th. Now, Ms. Barger, are you and your client both in agreement that this matter can be conducted by Zoom rather than her appearing before the court for an in-person hearing?
Yes, Your Honor.
And you're all right with that, Ms. Steinmetz?
Yes, sir.
All right. Now, Ms. Steinmetz, I've been presented with a plea of guilty form, which indicates you're going to withdraw your not guilty plea and plead guilty. I'll hold this first page up to you. It has your name, case number, plea of guilty, and the charge. I'll hold that up to the camera. You can see that there.
Yes, sir.
And you recognize that document?
Yes, sir.
All right. On page 3, there's a sentence about a third of the way down the page. It says, I enter this plea voluntarily. Immediately below that appears to be a signature, Brenda Steinmetz, and a date of 1/30/23. I'll hold that up to the camera and ask you if you recognize that.
Yes, sir.
And that's your signature?
Yes, sir.
And you signed this document on the 30th, which would have been Monday?
Yes, sir.
And before you signed it, did Ms. Barger go over it with you and explain everything to your satisfaction?
Absolutely.
All right. And when you signed it, did you understand that it was an agreement to plead guilty, which means there won't be a trial? The next step in your case would be a sentencing hearing?
Yes, sir.
And did you have enough time to fully consider this matter before making this decision?
Absolutely.
And are you entering into the agreement to plead guilty voluntarily?
Yes, sir.
Now, the agreement states on page 1 that you're going to withdraw your not guilty plea and plead guilty to the single count in the indictment of aggravated possession of methamphetamine. under 2925.11 of the Ohio Revised Code, a fifth-degree felony. Further states that you understand that the maximum prison term for that could be 12 months. Minimum would be 6. There'd be a possible fine of $2,500 and a possible license suspension of 6 months to 5 years. Do you understand that?
Yes, sir.
And are you facing any felony charges anywhere else?
No.
Are you currently on probation, parole, community control, or post-release control for a felony in this state?
Yes.
What is that?
I'm on parole for child support.
Okay. I don't know.
Your Honor, she's on post-release control.
Yes, that's what I was looking for. I don't know, was there a notice of that?
Filed.
Yep, here it is. I
Filed
found
January
it.
12th.
All right. January 12th, okay. All right. And according to that, at the time this was filed, excuse me, January 12th, there were 507 days left, so another 19 days have passed, so that means it's about, looks like 588 days would be left as of this time. So if you are convicted of this offense and sentenced to prison, then that time could be added to your sentence. Do you understand that?
Yes, sir.
All right. Now, under the law, you're not required to be sentenced to prison for this offense. I can impose what's called non-prison or community control sanctions, which means instead of going to prison, you can be put under the supervision of a probation officer on a term set by the court. If it could be for up to 5 years. If during that period of time the probation department felt that you had failed to comply, then they could file a written notice of that with the court. There would be a hearing. The outcome of that hearing was that you had failed to comply. Then at that time, the court could revoke your community control and sentence you to a period of 12 months plus whatever time is left on your PRC at that time, which would have to be served consecutively the sentence in this case. Do you understand that?
Yes, sir.
Now, under the law, if you're convicted of this offense and sentenced to prison, upon completion of the prison term imposed, post-release control is optional. And so it doesn't have to happen, but the Department or Adult Parole Authority could exercise their option under the law, put you under supervision of a parole officer for a period of up to 2 years under the terms they set. And if during that period of time they did not comply, or they felt that you did not comply, they would have the authority to return you to prison even though you served the entire term set by the court for an additional period of up to 1/2 of your prison term for one or more violations. But if you commit a new felony, then in addition to whatever sentence the judge in a new case can impose upon you, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively the sentence in the new case. Do you understand that?
Yes, sir.
All right, now, the charge in this case reads that on or about September 1, 2022 in Highland County, Ohio, that you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, methamphetamine, in violation of Section 2925.11 of the Ohio Revised Code. So that's the charge of aggravated possession of methamphetamine, a fifth-degree felony with the penalties, as I've described, of 6 to 12 months in prison. There could also be a fine of up to $2,500, and there could be a suspension of your driver's license for a period of 6 months to 5 years. Now, do you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged you did it?
Yes.
Have you discussed the charge in the case, possible legal issues in the case, possible defenses you might try to raise at trial, and possible outcomes of a trial with your attorney?
Yes.
Are you satisfied with her advice and competence in this matter?
Absolutely.
Are you under the influence of any types of drugs or alcohol at this time?
No.
Has anyone threatened you to make you plead guilty here today?
No.
Now, the agreement states on page 2, it's underlined in bold, defendant shall enter a plea of guilty to the indictment, state defense jointly recommend community control, and the defendant be referred to drug court. Is that your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty here today?
No.
Now, under the law, Ms. Steinmetz, the matter of sentence is up to the judge, not the parties. And so even though there's an agreement that you should get community control and possibly drug court, the final decision is up to the court, not the parties. So if you plead guilty, I don't have to follow the recommendation. I could decide to go ahead and send you to prison for 6 to 12 months plus whatever time's left on your PRC time consecutive to that. You understand that?
Absolutely.
All right. All right. Now, do you hold any license or certification from any state governmental agency that regulates any occupation or profession in this state?
No.
Right, you have certain rights you have to understand before I can accept a plea of guilty. First, you have a right to have an attorney. and Ms. Barker was appointed to represent you. That wasn't simply to work the case out, but to provide any defense that could be available to you under the law that you would like her to provide. So, if you decide that you do not want to do this, that you want to defend against the charge, she'll continue to represent you and defend you, including a trial if that's what you want. You understand that?
Yes, sir.
Right, now, Ms. Steinmetz, under the Constitution, you have a right to have a jury trial in this matter in which 12 people will be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After 12 of those people are selected, evidence would be presented. The judge would instruct them on the law, and that group of 12 jurors would have to decide by unanimous verdict, meaning they would all have to agree as to whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up the right to have a jury trial. In that case, you'd have what's called a court or bench trial, which means that instead of a jury hearing the evidence, it would be the judge who would hear the evidence. The judge would apply the law. The judge would decide whether or not the state proved your guilt. Do you understand that?
Yes, sir.
Now, under the Constitution and the law of this state, you have a right to confront witnesses against you and to cross-examine them through your attorney. So what that means is that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else. After the prosecutor is done asking questions, your attorney will ask questions. That's called cross-examination, the purpose of which is to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to use the power of the court to compel or force witnesses to be in court to testify on your behalf, the same as the state. So if you have witnesses you're not certain are going to come in voluntarily, your request, the court issues a court order that's called a subpoena, and that would force those people to come to court to be available to testify if you wanted them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court to testify against you. Do you understand that?
Yes, sir.
Right now, under the Constitution, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. You make that decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it, with one exception. If there's a jury trial and you don't testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Right now, under the Constitution, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charged by proof beyond reasonable doubt. So the burden of proof isn't on you to try to prove you're not guilty. The burden is upon the state to prove that you are guilty. In fact, at trial, you're not required to put on any evidence at all. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond reasonable doubt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Right now, originally you entered a plea of not guilty. Not guilty plea denied the allegation in the indictment, denied you committed any crime, and it exercised or invoked all the rights I've just described. Now, if you change your plea from not guilty to guilty, that's the complete opposite of the not guilty plea. The guilty plea admits the allegations in the indictment, admits that they're a crime, that you committed that crime. And that plea waives, gives up all the rights that I've just described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty waives or gives up your right to have a jury or court trial, waives or gives up your right to confront witnesses against you and cross-examine them through your attorney. Waives or gives up your right to use the power of the court to compel or force witnesses to be in court to testify for you, the same as the state. It waives or gives up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. It waives or gives up your presumption of innocence, because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives or gives up your right to file a motion to suppress or any other pretrial motion. Now, if you are sentenced to the maximum sentence or under other certain circumstances, the court could, or you could file an appeal, but that would have to be filed within 30 days of the sentencing entry being filed. Do you understand all of that?
Yes, sir.
And Ms. Steinmetz, are you a citizen of the United States?
Yes, sir.
Now, do you have any questions about the plea or the possible, about the charge or the possible penalties?
No, sir.
You understand those?
Yes, sir.
Have any questions about the plea agreement?
No, sir.
You understand it?
Yep.
And you understand the matter of sentencing is not binding, the recommendation is not binding on the judge?
Yes, sir.
Yeah. Do you have any questions about the constitutional rights I've explained?
No, sir.
And do you understand those?
Yes, sir.
Do you have any questions about the plea of guilty what it means or what will happen if you enter that plea here today?
No, sir.
You understand that?
Yep.
Is there anything you would like to speak with your attorney about before we go any further? I forgot to mention that to you, but I can put you and her into a breakout room for just the two of you to be talking to each other privately, and the deputy would step out of the room if you do that. Do you need to do that for any purpose?
Not at all.
All right, have any questions about anything that I've explained to you here today?
No, sir.
Then is it your decision to voluntarily go forward and enter a plea of guilty pursuant to the terms of the plea agreement that we've just gone over?
Yes, sir.
Then as to the charge which alleges that on or about September 1, 2022 in Highland County, Ohio, that you did knowingly obtain, possess, or use a Schedule II controlled substance with methamphetamine, violation of Section 2925.11 of the Ohio Revised Code, charge of aggravated possession of methamphetamine, a fifth-degree felony carrying a possible prison term between 6 and 12 months, plus an additional up to currently 587 days, it would be decreased up until the date of your sentencing, and that would be served consecutively if you were sent to prison. Fine of up to $2,500 and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
All right, thank you. The court finds that on this day in open court, the defendant was advised of all of her constitutional rights, made a knowing, intelligent, and voluntary waiver of the same pursuant to Criminal 11. Plea is accepted and ordered filed. Defendant is found guilty of the offense as charged, a fifth-degree felony. The court will order a pre-sentence report and will order that the case be referred to the drug court for evaluation. We will set the sentencing date for March 8th at 9 a.m. Bond will be continued. Now, Ms. Barker, if you can be in touch with probation department about possible residential placement for her prior to the sentence, the court would entertain that. So I know Ms. Sturgill's out this week on vacation, but you could contact Ms. Davis there at the probation department to discuss that.
I actually contacted Ms. Sturgill already. She's on a list.
Okay. All right. Anything further then?
There, Your Honor.
All right. Thank you, Ms. Steinmetz.
Thank you.
Case number 22 CR 201. State of Ohio versus Darcy Marie Benninger. This hearing is being conducted by Zoom. Ms. Benninger is appearing on the screen under on a phone as marked Samsung SM134DL. Her attorney is William Armentrout. He's appearing on his office, appearing from the prosecutor's office, Assistant Prosecutor King. The defendant is charged in a looks like a 12-count indictment. This is a first pretrial, final pretrial. Actually, it's a final pretrial, and trial is set for December 23rd. Now, discovery complete, counsel?
It is, Your Honor.
Okay.
If I may, Your Honor, the state made a revised offer to my client. I've discussed that with her. She's agreed to accept that. I've not been able to get her in to sign the paperwork yet, so if we could schedule this for Monday would be bad. I have several times on Tuesday if we could do that to enter the plea.
Are you scheduled here on Tuesday for anything?
No, sir.
Let me see what we got.
I have a 9 o'clock in municipal court. That's all I have out there that morning.
That is grand jury day.
Okay.
So, but let me get the calendar here. This will be an in-person hearing.
Yes.
I need the calendar. Wednesday, how's next Wednesday look?
Good.
Oh, yeah, that's a,
You had put that on there a long time ago.
yeah, but that's wrong.
Yeah, I know.
It's, okay, all right. How about 10 o'clock, Mr. Armentrout?
On Tuesday?
No, Wednesday.
Um,
Tuesday we have grand jury.
I've got a domestic at 10 o'clock, Your Honor, which probably will take not more than a half hour. Could we say 10:30 or 11?
Yeah. All right, we'll just say Wednesday, the 8th,
Yes.
at 11 a.m.
Okay, that'll be fine.
All right, now, Ms. Benninger, you'll need to appear here in person
Okay.
at the courtroom. All right, anything else then?
Only, Your Honor, Darcy, in about an hour this afternoon, Darcy, call my office to get an appointment to come in and go over the paperwork, okay?
Okay.
That's all, Your Honor. Thank you.
All right, thank you. You go ahead and sign off, Ms. Benninger, if you wish.
Okay, thank you.
All right, I see that Mr. Campbell is on. You are Dylan T. Campbell, appearing on the screen, marked Dylan Campbell.
Yes, sir.
All right. This hearing is being conducted by Zoom. This is a pretrial. Mr. Campbell's attorney is Sarah Barger, appearing from her office. Appearing from the prosecutor's office by Zoom is Mr. King. The defendant is charged with one count of aggravated possession of methamphetamine, a fifth-degree felony. Let's see. This matter is, I think this is a final pretrial. We have a trial date on February 23rd. So discovery complete on both sides?
It is from the state, Your Honor.
Yes, Your Honor.
All right, and no pretrial motions been filed?
Not at this time, Your Honor. Your Honor, I would request a continuance, and I don't think there's going to be a need for a trial, but just give the state and I a little more time to work something out. The state has been in agreement, or is in agreement, with a continuance of today's hearing and set it for another final.
All right. I don't believe there's any speedy trial time issue on this case. He's been on bond all the time, hasn't he?
Yes.
All right, well, if I continue the case, Mr. Campbell, that would extend any speedy trial time. We have 270 days to bring you to trial, and then every day you spent in jail counts 3 for 1. But you've been out of jail most of the time, so I think there's plenty of time on this case. But nonetheless, if I grant the continuance, your request, that tolls the speedy trial time. You understand that?
Yes, sir.
And you have any problems with that?
No, sir.
Okay. So you agree to waive and extend the speedy trial time?
Yeah.
Okay. All right, the court will grant the motion to continue trial date that is set for February the 23rd. And we'll set it for another final pretrial on March the 8th at 2 p.m. Trial date will be March 23rd at 8 a.m. And the speedy trial time is told pursuant to RC 2945.72H on the defendant's motion. So you won't need to be here on the 23rd, Mr. Campbell, but you will need to be available. We'll probably do the final pretrial by Zoom. In fact, I'll go ahead and mark it now. And then if there is a trial, it will be in person.
Okay, yes, sir.
All right. Anything further from counsel then?
No, Your Honor.
You need him to contact you, Ms. Barger, or make an appointment?
Yes, I'll contact him.
All right, thank you. All right, I have a lady on the phone that says mom's phone. All right, this is case number 22CR171, State of Ohio versus Bobby Renee Foster. And Ms. Foster is appearing on the screen on the phone marked Mom's phone. Her attorney is Sarah Barger, and representing the state is Adam King. This is a Zoom hearing. The defendant is charged with aggravated possession of methamphetamine and aggravated possession of drugs. This is a final pretrial and a trial set for the 23rd. Now, I have received a motion for intervention in lieu of conviction, and also the stipulated questions, it looks like, were signed, and I have the original here. So the court will order a referral to the probation department for a pre-hearing report. Also, a evaluation for substance abuse and/or mental health issues is ordered. And are you in any treatment now, Ms. Foster?
I start FRS group 3 times a week on Monday.
All right. So you'll need to get a waiver to them and go back to see make an appointment to see Mr. Arjima as soon as possible.
Yeah, I go tomorrow evening.
Okay, and then he'll make an appointment for you for the interview, and you'll need to make sure you get all that information to them.
Okay.
Now, you've been testing positive pretty regularly for various things. You know, one of the requirements if you get into intervention is that you are not to use any kind of controlled substances for a year unless they're validly prescribed. So you're going to have to be clean by the time we have this hearing. Otherwise, there's no point in putting you in it because you're not going to make it.
Okay.
And I think you might want to talk to Mr. Arjima or Mr. Fulton. I'm not sure who will do this report, but it may be that we need to look at potentially her getting into a residential treatment since she's tested positive as recently as yesterday.
It was negative. Yes, it was negative yesterday. He said when I went in.
I have here positive for THC and kratom. Is that what it was, Mr. Arjima?
Yes, Your Honor.
All right.
The meth was negative, but
okay. Yeah. Well, you can't have any kind of drug. It's not just the drug you're charged with, or the drug that that you had before. You get and kratom. We don't allow kratom either, because that's just
I'm
another.
not real sure what that is, but
Yeah. Well, it's fake marijuana. Fake marijuana. Some of the stuff you get in the stores, and pot. So, you know, you last tested positive for meth 2 weeks ago, 13th. So that's good. But anyway, I'm just giving you a heads up. You need to get clean. So, and if you're having any trouble, then it may be you'll need to get into a residential program. So I'll wait and see, and we'll decide what happens at the hearing. So we'll schedule the hearing then. For March 8 at 10 o'clock. So you don't need to be here on February 23rd. You'll continue to report, stay in your treatment, sign your waiver so they can get or release of information. And if you have any more positive tests before the hearing, just tell you now, unless you're in a residential treatment, it's probably not going to be granted because there's no point in it if you can't stay clean between now and then. And again, if you do continue to test dirty, you get into residential, then that would be, I would still, consider it at that time. So, but that's what you'll need to do. All right. Anything further from counsel?
No, Your Honor.
All right. Thank you. All right. Let's see. Now the rest of our hearings aren't scheduled till 2. All right, Kyle Holland. All right, this is case number 22CR214, State of Ohio versus Kyle Holland. And you're Kyle Holland appearing on the screen. It's marked Kyle Holland down in the corner.
Okay, can you hear me now, sir?
Yeah, but you're not on. You just go ahead and mute, and we'll call you when we're ready. What's your name?
Dennis Winters, sir.
All right, well, we're doing another case before yours. Maybe a couple.
Yep. Yes, sir.
All right, just go ahead and mute.
Okay, I'm trying to figure that out. Okay, mute. I see it. Thank you, sir.
All right. Now, you're Kyle Holland?
Yes, Your Honor.
All right, didn't hear you there because the other gentleman was much louder. All right, and if you would, try to keep your voice up so we can hear you, okay?
Okay.
You might want to move a little closer to that if you can. Mr. Holland is appearing by Zoom from, are you at the counseling center?
Yes, Your Honor.
All right. His attorney is William Armentrout, appearing from his office. Appearing from the prosecutor's office is Assistant Prosecutor King. The defendant is charged with aggravated trafficking in methamphetamine, aggravated possession of methamphetamine, and aggravated possession of a fentanyl-related compound. This is a pre-trial being conducted by Zoom, final pre-trial. Trial set for the 21st of February. Mr. Holland, I received a plea of guilty form that indicates you're going to plead guilty to count 3 in this case. And I'm going to, it looks like you signed this and it was faxed to Mr. Armentrout. And then I see Mr. King's signature and then Mr. Armentrout's on a separate page. But I'm going to hold this up to you. First of all, page 1 has your name and case number and says you're going to plead guilty there. And can you see that form? I'm holding up the camera, okay?
Yes.
And you recognize that form?
Yeah, I do.
All right, and on the third page, about a third of the way down, there's a sentence that reads, I enter this plea voluntarily, and immediately below that appears to be the signature of Kyle Holland. So I'll hold that up to the camera, and is that your signature as well?
Yes, it is.
When did you sign this agreement, Mr. Holland?
Yesterday.
All right, and you've been talking to Mr. Armentrout about this before that?
Yes, I did.
And did he go over the agreement with you and explain everything to you?
Yeah, he did.
And did you understand that by signing this agreement, you're agreeing to plead guilty, which means there won't be a trial, and the next step would be a sentencing hearing?
Yes, Your Honor.
And did you have enough time to fully consider this matter before you made that decision?
Yes.
All right, and I didn't say this earlier, but at any time during this hearing, if you would like to speak with Mr. Armentrout, I can put you and him into a breakout room to talk privately, okay?
Okay.
And then also, I didn't ask earlier, but you're okay, Mr. Holland, with appearing here by video rather than having to drive back up here and appear in court in person?
Yes.
So you're waiving your physical presence in the courtroom?
Yes.
And you're agreeable to that, Mr. Armentrout?
Yes, Your Honor.
All right, thank you. All right, now, Mr. Holland, the agreement states you're going to plead guilty to count 3, aggravated possession of a fentanyl-related compound under 2925.11 of the Ohio Revised Code, a 4th-degree felony. Further states that you understand the maximum penalty for that could be 18 months in prison, the minimum is 6. There could be a fine of $5,000, could be a license suspension of 6 months to 5 years. Do you understand that?
Yes.
And are you facing any felony charges in any other jurisdiction?
No, Your Honor, I'm not.
And are you currently on probation, parole, community control, or post-release control for a felony in the state of Ohio?
Just with you guys.
All right. Now, under the law, if you're convicted of this offense and sentenced to prison, then the adult parole authority could, after you finish that term set by the court, decide to put you under post-release control for a period of up to 2 years. They don't have to, but they can. But if they do, you'll be supervised on the terms they set. And if during that period of time they determine that you have failed to comply, then they could return you to prison, even though you served the entire term set by the court, make you serve an additional period of up to, in this case, half of your prison term for 1 or more violations. But if you violated, if you were convicted, I should say, of another felony while under post-release control, then in addition to whatever whatever penalty could be imposed for that new offense, that new felony, the judge in that case could also sentence you for committing that offense while under post-release control, in this case, to an additional period of 1 year, or whatever date was, whatever time is left on the post-release control, whichever is greater. And if that occurred, that would be served consecutively to the sentence in the new case. Do you understand that?
Yes.
All right. Now, under the law, I'm not required to sentence you to prison for this offense. I can impose what's called non-prison or community control sanctions, which means that instead of going to prison, you would be put in under the supervision of a probation officer under the term set by the court for a period of up to 5 years. And if during that period of time the probation department felt that you were non-compliant, then they would file a notice of that with the court. There would be a hearing, and if the outcome of that hearing was that you had failed to comply, then at that time the court could revoke your community control and then sentence you to prison for the 18 months and fine you $5,000. Do you understand that?
Yes.
All right. Now, the charge in this case alleges that on or about May 5, 2022 in Highland County, Ohio, that you and Stephanie P. Fleming did knowingly obtain, possess, or use a Schedule II controlled substance, to wit fentanyl and parafluorofentanyl, in an amount equal to or exceeding 1 gram but less than 5 grams, in violation of Section 2925.11 of the Ohio Revised Code. So that's the charge with the penalties that I've just described. Now, do you understand what it is you've been charged with in that count of the indictment, what the state said you did, when, where, and how they alleged you did it?
Yes.
Have you discussed the nature of those charges, that charge, the evidence in the case, possible legal issues in the case, possible defense you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes.
Are you satisfied with his advice and competence in this matter?
Yes, Your Honor.
Are you under the influence of any types of drugs or alcohol at this time?
No, Your Honor.
Have any threats been made to get you to plead guilty here today?
No.
Now, on page 2, there are 3 sentences that are printed in bold and underlined that read, "The defendant shall enter a plea of guilty to count 3. The state will dismiss remaining counts. State and defense jointly recommend community control and substance abuse treatment. Defendant agrees to cooperate fully in prosecution of the co-defendant." Is that your understanding of the agreement?
Yes.
Does anyone promise you anything other than that to get you to plead guilty here today?
No.
Now, under the law, the matter of sentence is up to the judge, not the parties. And so, even though there's an agreement that you should get community control or probation, if you plead guilty, once I've heard all the information that's submitted, I may decide that's not the correct sentence, and I could sentence you to prison, and it could fine you, and it could suspend your driving privileges for 6 months to 5 years. You understand that?
Yes.
All right. Now, do you hold any license or certification from any state agency that regulates any occupation or profession?
No.
Now, you have certain constitutional rights, if you understand, before I can accept your plea. And first, you do have a right to have an attorney, and if you don't have the money to hire one, the court will appoint one for you, which is what I did in this case. However, that wasn't simply to work the case out, but to provide any defense that might be available to you under the law. And so if you decide you don't want to plead guilty, you're still going to be represented by Mr. Arbitrout. He'll defend you, including a trial if that's what you want. Do you understand that?
Yes, Your Honor.
All right. Now, under the Constitution, you have the right to have a jury trial in this matter, in which the 12 people would be selected to serve on a jury from a group of citizens that are summoned for jury duty on your trial date. After they are selected, the evidence will be presented, and then the judge would instruct that jury on the law, and the jury then would have to decide by unanimous verdict whether the state proves your guilt of the charge by proof beyond reasonable doubt. Now, that verdict would have to be unanimous, meaning all 12 would have to agree. Now, if you didn't want to have a jury trial, but you did want to plead guilty, you can waive, which means you give up in writing your right to have a jury trial. In that case, you would have what's called a quarter bench trial, which means that instead of a jury hearing the evidence, it would be the judge who would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proves your guilt. Do you understand that?
Yes, Your Honor.
All right, now under the Constitution, you have a right to confront the witnesses against you open court and cross-examine them through your attorney. So what that means, that the witnesses against you have to come into court, testify in front of you, your attorney, and anyone else is present. After the prosecutor is done asking questions, your attorney asks questions. That's called cross-examination. And the purpose of that is to try to bring out evidence that helps your side of the case. Do you understand that?
Yes, Your Honor.
All right, now under the Constitution, You have a right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, court issues a court order called a subpoena, and that force those witnesses to come to court to be available to testify if you wanted them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court. Do you understand that?
Yes, Your Honor.
Right, under the Constitution, Mr. Holland, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, you decide. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person, and no one's even allowed to talk about it except in one situation. If there's a jury trial, you don't testify. The judge instructs the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, Mr. Holland, you're presumed innocent of this offense until proven guilty by the state of Ohio on every essential element of the offense charged. So, if you have witnesses you're not certain are going to come in voluntarily, I'm sorry, that's the wrong one. I was looking at something else. What that means is that the burden of proof isn't on you to try to show you're not guilty simply because you've been accused. In fact, under the law, you don't have to put on any evidence at all at trial. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, Your Honor.
All right, now, originally you entered a plea of not guilty. Not guilty plea denied the allegation in the indictment, denied you committed any crime, and exercised or invoked all the rights I just described. If you change your plea from not guilty to guilty, that is a complete opposite of not guilty plea. The guilty plea admits the allegation in the indictment, admits that they're a crime, count 3, and that you committed that crime. And that plea waives, gives up all the rights that I've just described for you, except your right to have an attorney. You always have a right to have an attorney no matter what your plea, but with that exception, your plea of guilty waives, gives up your right to a jury or court trial, waives, gives up your right to confront witnesses against you and to cross-examine through your attorney, waives, gives up your right to use the power of the court to compel or force witnesses to come to court to testify on your behalf, the same as the state. It waives, gives up your privilege against self-incrimination, because if you say you're guilty, that's what you use to find you guilty. And it waives, gives up your presumption of innocence, because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives, gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I sentence you the maximum sentence, or under those certain limited circumstances, you can file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all that?
Yes, Your Honor.
And are you a U.S. citizen?
Yes.
Now, do you have any questions about the charge, the possible penalty?
No, Your Honor.
Do you understand it?
Yes.
Have any questions about the plea agreement?
No, Your Honor.
You understand it?
Yes.
Have any questions about the constitutional rights I explained?
No, Your Honor.
You understand that?
Yes, I do.
You have any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, Your Honor.
You understand that?
Yes.
Is there anything you need to speak with Mr. Armentrout about before we go any further? If you do, I can put you and him into a breakout room, just the two of you talk with no one else seeing or hearing you.
No, not at the moment. We talked yesterday.
All right. You have any questions about anything that I have explained today?
No, Your Honor.
Then is it your decision to withdraw your plea of not guilty and voluntarily enter a plea of guilty to count 3 pursuant to the agreement that we've just gone over?
Yes.
Then as to the charge in count 3, which alleges that on or about May 5, 2022, in Highland County, Ohio, you and a Stephanie P. Fleming did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, fentanyl, a parafluorin fentanyl, an amount equal to or exceeding 1 gram but less than 5 grams, in violation of Section 2925.11 of the Higher Revised Code. Charge of aggravated possession of fentanyl-related compound, 4th-degree felony, carrying a possible prison term of between 6 and 18 months, and a fine of $5,000, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
All right, thank you. The court finds on this day in open court, defendant was advised of all his constitutional rights, made no intelligent voluntary waiver of the same, pursuant to Criminal Rule 11. Please accept it, order filed. Defendant is found guilty of the offense. Court refers this matter for a pre-sentence investigation, and bond will be continued. The sentencing will be March 8th, 2023, and that can be by Zoom as well if you're still at the counseling center. All right. Mr. Arjima, are you going to get in touch with him, or have Mr. Folk get in touch with him?
Yeah, we'll get in touch.
All right, thank you. All right, you can go ahead and sign off then, Mr. Holland. Thank you.
Thank you.
All right, is camera... CR232, State of Ohio versus Kimra Snyder. Mr. Snyder is appearing by Zoom on the phone marked Kimra Snyder on the screen. Her attorney is William Armentrout, appearing by Zoom. Also appearing by Zoom is Assistant Prosecutor King on behalf of the state. This is a pretrial, the first pretrial, final pretrial set for the 15th of February. Trial date's March 6th. Defendant's charged with illegal conveyance as well as aggravated possession of fentanyl. Now, I do see that discovery was provided by the state and bill of particulars. Have you got your discovery in yet, Mr. Armentrout?
I have, Your Honor. It was filed this morning.
Okay. You anticipate any pretrial motions?
No.
All right. And has there been a written plea offer?
There has. My client's not aware of it yet. She has stayed in contact with me, Your Honor. I have good contact information, and Kimmer will contact me after court today to schedule an appointment to go over all that.
Okay. All right. Anything else to discuss then?
No.
All right, Mr. Snyder, make sure you call Mr. Armentrout's office to get an appointment to talk about that issue. All right? Thank you.
All right, thanks, Your Honor.
All right, Dennis Winters. Ms. Witch went on mute there. All right, this is case number 22 CR233. No, wait a minute, that was, yeah, okay. Yeah, 223, State of Ohio versus Dennis Winters. Mr. Winters is appearing by Zoom. On his phone, appearing on his behalf is his attorney, Danielle Witt, and appearing on behalf of the state is Assistant Prosecutor King. I believe that this is a first pretrial. Final pretrial will be February 15, and trial date is March the 6th. I do see that state provided the bill of particulars and discovery, and you received that, Ms. Witt?
Yes, Your Honor.
All right. Your discovery is due by final pretrial in 2 weeks, and do you anticipate any pretrial motions?
No, none at this time.
And has there been a written plea offer received?
There has.
And is your client aware of it?
Not yet. I need to get a contact number for him.
All right, Mr. Winters, you want to give your attorney that number?
Yes, ma'am. Right now?
Yes.
Okay, it's 740-628-4556, sir.
Okay. All right. Well, she's going to try to get in touch with you, set up an appointment to make sure you get back to her. And if you don't hear from her in a day or so, then you call her.
Yes, sir.
All right. Anything further to discuss on this case?
No, Your Honor.
All right.
No, Your
Thank
Honor.
you. All right. You go ahead and sign off, Mr. Winters. All right. James Brown. Unmute yourself, please.
There you go. Can you hear me?
Yes, I can. All right, this is case number 22, CR228, State of Ohio versus James V. Brown. Mr. Brown is appearing by video or by Zoom. His attorney is William Armentrout. He is appearing as well from his office. Appearing from the prosecutor's office by Zoom is Mr. King. The defendant is charged with theft by deception and forgery. This is a final pretrial. Trial date is set for the 21st. I believe that the discovery I see is complete by the state. I don't see your discovery, Mr. Armentrout. Have you filed that?
It was filed on January 4th, Your Honor.
All right. Well, I didn't look that far back. I was looking more recently. Okay. There are no pretrial motions?
No.
All right. And where do we stand on the case
Your
at
Honor,
this point?
my client was presented with a final offer yesterday. I haven't had a chance to discuss it with him. Wonder if we could set this for Wednesday at 11:30.
All right.
Right after we did Darcy Vinegar at 11.
All right. Okay, Mr. Brown, then we're going to set this for hearing at Wednesday. That'll be a week from today. That's the 8th at 11:30. And you'll need to appear in person here at the courthouse.
Okay.
Second floor.
Okay.
And you want him to call you, Mr. Armentrout?
I'll call you, James, here in a little bit.
Okay. All right.
All right. Anything further then on this case?
No, Your Honor.
All right. Thank you. All right, Kyle Combs.
Yeah.
22 CR 239, State of Ohio versus Kyle Combs. You are Kyle Combs appearing there. Is that from the counseling center?
Yes, sir.
All right. This hearing is being conducted by Zoom. His attorney is Danielle Witt, appearing from her office, appearing from the prosecutor's office, Assistant Prosecutor King. The defense charged with a single count of aggravated possession of fentanyl-related compound. This is the first pretrial. Final pretrial is the 15th, and a trial date is March the 6th. All right, I see the discovery has been provided, the bill of particulars. Did you, have you filed your discovery yet, Ms.
No,
Witt?
not yet, Your Honor.
Yours will be due by final pretrial. Do you anticipate any pretrial motions?
No, none at this time.
And has there been a written plea offer received?
There it has been, and he is aware of it.
All right. All right. Are there any other matters to discuss at this point then?
No, Your Honor.
No, Your Honor.
All right, we'll have our final pretrial by Zoom also. Mr. Combs, you'll still be down there, I assume?
Yes, sir.
Okay. So we'll do that, but final pretrial by Zoom then. Thank you.
Have a good day.
All right.
Is that it?
All right, case number 22 CR 229, State of Ohio versus by Zoom from the probation department. On the screen it's marked Kira Watson. His attorney is Catherine Hapner, appearing from her office, and appearing from the prosecutor's office is Assistant Prosecutor King. Defendant is charged with receiving stolen property, a fourth-degree felony. This is a final pretrial, and the trial is set for March the 6th. Now, I have received a plea of guilty form, Mr. Martin, which indicates you're going to withdraw your not guilty plea and plead guilty. I'm going to hold up to the screen the front page of that to make sure we're talking about the documents you recognize. Is that the plea agreements that you looked at earlier?
Yes, Your Honor.
And on page 3, there's a sentence that about a third of the way from the top that says, "I enter this plea voluntarily," and immediately below that appears to be the signature, Marty Martin. I'll hold that up to the camera and ask you if that is your signature.
Yes, Your Honor.
Okay. Now, before we go any further, since do you, Ms. Hapner, and your client both agree to his appearance by video, remotely by Zoom, rather than in-person courtroom appearance?
Yes, Your Honor.
And you're all right with that, Mr. Martin?
Yes, Your Honor.
Okay. Since you're not sitting in court next to your attorney, if any time during this hearing you need to ask her any questions, you let me know, and I can put the two of you in what's called a breakout room, where it will be just the two of you on the screen talking, and no one else will be able to see you or hear you, okay?
Okay, thank you.
All right. Now, Mr. Martin, did you just sign this agreement today, or was it before today?
No, it was before today.
All right. And when you signed it, was your attorney there to go over it with you and explain everything to you and answer any questions?
Yes.
And do you feel you had enough time to fully consider the matter before making this decision?
Yes.
And is this the decision you still want to do, is to go forward with this plea agreement?
Yes, Your Honor.
Did you enter into the agreement to plead guilty voluntarily?
No. I mean, I'm plead guilty.
Okay, well, what I meant is, did you enter into it voluntarily, or were you coerced into doing it? Was somebody threatening you, holding a gun to your head or anything like that?
I volunteered.
All right. Okay, so you basically, after you looked at everything, your options and everything, and discussed it with your attorney, decided this was the course of action that was in your best interest?
Yes, Your Honor.
Okay, so that's what I would call voluntarily, okay?
Okay, yeah.
All right, thank you.
Thank you.
Now, the agreement states you're going to plead guilty to the charge in the indictment of receiving stolen property under 2913.51 of the revised code, a fourth-degree felony. It further states that that it could be subject to a penalty of imprisonment of up to 18 months, 6 months as a minimum if prison's imposed. Could be a fine of up to $5,000. Do you understand that?
Yes, Your Honor.
And are you facing any charges in any other jurisdiction right now?
No, Your Honor.
Are you currently on probation, parole, community control, or post-release control from any jurisdiction right now?
No, Your Honor.
Right now, under the law, Mr. Martin, if you are convicted of this offense, and if you should be sentenced to prison for this offense, then upon completion of that prison term, it is possible that the Adult Parole Authority would use the option that they have under the law to put you under post-release control supervision for a period of up to 2 years. If that happened, you would be supervised by a parole officer in the term set by the APA, Adult Parole Authority, because the court's not involved with that. If during that period of time that you were being supervised, they determined that you had not complied, they could return you to prison to make you serve an additional period of up to, in this case, half of your prison term for one or more violations. But if you commit a new felony while under post-release control, then in addition to whatever sentence could be imposed by the judge in that new felony case, that judge could also sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater. And if that occurred, that would have to be served consecutively the sentence in the new case. Do you understand that?
Yes, Your Honor.
All right, now under the Constitution, under the law, Mr. Martin, I'm not required to sentence you to prison for this offense. I can't impose what's called community control, which is the same as probation. What that means that is instead of going to prison, you would be put under supervision of a probation officer for a period of up to 5 years under terms set by the court. If during that period of time the probation department felt that you were not complying, they would file a written notice of that with the court, serve a copy on you. There would be a hearing. You'd be entitled to have an attorney at that hearing. If the outcome of that hearing was that you'd failed to comply, then at that time the court could revoke your community control, then sentence you to prison for 18 months, fine you $5,000. Do you understand that?
Yes, Your Honor.
All right, now, Mr. Martin, the charge in this case alleges that on or about October 14, 2022 in Highland County, Ohio, you did receive, retain, or dispose of certain property being various antiques, barn items, and household items, and other miscellaneous items of property of another Ginger Parks, and that you knew or had reasonable cause to believe the property had been obtained through the commission of a theft offense, the value of the property being equal to or exceeding $7,500 but less than $150,000, in violation of Section 2913.51 of the revised code. So that's the charge of receiving stolen property with the penalties I've described. Now, do you understand what it is you've been accused of having done in that charge, what the state said you did, when, where, and how they led you did it?
Yes, Your Honor.
Did you understand the possible penalties for that offense?
Yes, Your Honor.
Have you discussed the nature of the charge, the evidence in the case, the possible legal issues in the case, the possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, Your Honor.
Are you satisfied with her advice and competence in this matter?
Yes, Your Honor.
Are you under the influence of any types of drugs or alcohol at this time?
No, Your Honor.
Are you taking any prescription drugs?
No, Your Honor.
Has anyone threatened you to make you plead guilty here today?
No, Your Honor.
Now on page 2, there's about 3 lines printed toward the bottom in ink, or dark black ink, and underlined, and I'll read those as follows. Defendant shall enter a plea of guilty to the indictment. State and defense jointly recommend community control. Defendant agrees to make restitution in full. Defendant agrees to cooperate fully in the prosecution of Christopher Hutchinson. Is that your understanding of the agreement?
Yes, Your Honor.
Does anyone promise you anything other than that to get you to plead guilty here today?
No, Your Honor.
Now, under the law, the matter of sentence is up to the judge, not to the parties. And so even though there's an agreement as to what the sentence should be, if you plead guilty, I don't have to follow that. I could end up sentencing you to prison or fining you if I thought that was the correct thing to do. Do you understand that?
Yes, Your Honor.
And do we have a number on restitution yet, Mr. King?
Your Honor, we're still working on that, but we will, if there is any, we'll have it by the sentencing hearing.
All right.
And Your Honor, just to clarify, the restitution will be joint and several between he and any other convicted co-defendants.
All right. Okay. And did you consult with the victim of the offense, Mr. King?
Yes, the state has, Your Honor.
All right. Thank you. All right. Now, Mr. Martin, do you hold any license or certification from any state governmental agency that regulates any occupation or profession in this state?
No, Your Honor.
All right. Now, under the law, you have a right to have an attorney to represent you in this matter, and if you couldn't afford to hire one would be, the court would appoint one for you, which I did. I appointed Ms. Hapner. Now, that wasn't simply to work the case out, but to provide any defense that might be available to you under the law that you would like her to provide. So if you decide you do not want to plead guilty, that you want to defend against this charge, she will continue to represent you, including a trial, if that's what you want. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, you have a right to have a jury trial in this matter, Mr. Martin, which means that 12 people would be selected from a group of citizens that live in Highland County, summoned for jury trial duty on your trial date. After they are selected, the evidence will be presented, and then they'd be instructed on the law by the judge. And then that jury of 12 would have to decide unanimously, meaning that all would have to agree on a verdict as to whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you did want to plead guilty, you can waive in writing, which means to give up, your right to have a jury trial. In that case, you would have what's called a court or bench trial, and that means that instead of a jury hearing the evidence, it would be the judge who would hear the evidence, apply the law, and decide whether or not the state proved your guilt. Do you understand that?
Yes, Your Honor.
Right now, under the Constitution, you have a right to confront the witnesses against you and to cross-examine through your attorney. So what that means is that the witnesses against you have to come into the court and testify in front of you and your attorney and anyone else that would be present in the courtroom. Once the prosecutor was done asking those witnesses questions, your attorney would ask questions, and that's called cross-examination. And the purpose of that would be to bring out evidence that helps your side of the case. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, you have a right to use the power of the court, Mr. Martin, to compel witnesses to come into court to testify for you, just like the state. So if you have witnesses you're uncertain will come in voluntarily to testify at your request, the court will issue a subpoena, and that is a court order that forces the people that are named in the subpoena to come to court to testify on your behalf if you want them to, even though they do not want to be involved or be present. And that's the same way the state's witnesses are forced to come in and testify against you at trial. You understand that?
Yes, Your Honor.
Right now, under the Constitution, Mr. Martin, you have privilege against self-incrimination, which means that you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. You decide. And if you decide not to testify, the fact that you did not testify cannot be used against you at any time by anyone at any time in the proceedings, including trial, except in one situation. It can't be used against you, and no one can even comment about it except in one situation. And that is, if there's a jury trial and you decide not to testify, the judge does instruct the jury that because that is your constitutional right, they cannot consider that failure to testify for any purpose. Do you understand that?
Yes, Your Honor.
Right now, under the Constitution, Mr. Martin, you're presumed innocent until proven guilty by the state of Ohio in every essential element of the offense charged. So what that means is that the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to put on any evidence at trial. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. You understand that?
Yes, Your Honor.
All right, now, originally you entered a plea of not guilty to the charge. The not guilty plea denied the allegations in the indictment, denied you committed any crime, and that plea exercised or invoked all of the rights that I've just described. Now, if you change your plea from not guilty to guilty, that is the complete opposite of the not guilty plea. The guilty plea admits the allegations in the indictment, and admits that they're a crime and that you committed the crime. And that plea waives, gives up all the rights that I've described for you today, except your right to have an attorney, because you always have a right to have an attorney no matter what you plead. But without exception, your plea of guilty waives, gives up your right to a jury or court trial, waives, gives up your right to confront witnesses against you and to cross-examine through your attorney, waives, gives up your right to use the power of the court to compel or force witnesses to come to court to testify on your behalf, the same as the state, waives or gives up your privilege against self-incrimination because you're saying you're guilty, that's what's used to find you guilty, and waives, gives up your right to file an appeal on any alleged issues of your violations of your rights you feel may have occurred up until this point in the case. If you are sentenced to maximum sentence under other circumstances, you can file an appeal. It would have to be filed within 30 days of your sentencing interview to file. It would also waive or give up your presumption of innocence. If I didn't mention that earlier, I forgot, but if I didn't, I'll mention it now, and that is that gives up your right to require the state to prove your guilt, because if you say you're guilty, they don't have to prove you're guilty. Now, it also would subject you to being sentenced immediately by the court if that's what the court thought was appropriate. Do you understand all of that, Mr. Martin?
Yes, Your Honor.
And are you a citizen of the United States?
Yes, Your Honor.
Now, do you have any questions about the charge or the possible penalties?
No.
You
No, Your
understand
Honor.
them?
Yes, Your Honor.
Have any questions about the plea agreement?
No, Your Honor.
You understand it?
Yes, Your Honor.
Do you have any questions about the constitutional rights I've explained?
No, Your Honor.
You understand those?
Yes, Your Honor.
Any questions about the plea of guilty, what it means, or what the consequences of that will be if you enter it here today?
No, Your Honor.
You understand that?
Yes, Your Honor.
Now, is there anything you would like to speak with Ms. Hapner about before we go any further?
No. I'm
Have
good,
any-
thank you.
All right, have any questions at all?
No.
Then is it your decision, Mr. Martin, to withdraw your not guilty plea, plead guilty to the charge in the indictment pursuant to the terms of this agreement that we just went over?
Yes, Your Honor.
Then as to the charge which alleges that on or about October 14, 2022 in Highland County, Ohio, you did receive, retain, or dispose of certain property being various antiques, barn items, and household items, and other miscellaneous items and property of another Ginger Parks, the said Marty Martin knowing or had reasonable cause to believe said property had been obtained through the commission of a theft offense, the value of the property being equal to or exceeding $7,500 but less than $150,000. In violation of section 2913.51 of the Ohio Revised Code, the charge of receiving stolen property, a fourth-degree felony, carried a possible prison term of between 6 and 18 months, fine of $5,000. How do you plead?
Guilty.
All right, thank you. The court finds on this day in open court, defendant was advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of the same, pursuant to criminal rule 11 of pleas, accepted, ordered, filed. Defendant is found guilty of the offense as charged. The court will order pre-sentence investigation under the same bond. So you need to contact the probation department about an interview time. Do you want him to call you, Mr. Fulton, or you want to call him?
He's here.
Oh, you're there. Okay, just see Mr. Fulton before you leave then. All right. Sentencing will be on March the 8th at 9 a.m. and the bond will be continued. All right. Is there anything further from counsel?
No, Your Honor.
All right, thank you. All right, Ms. Hapner, you have Mr. Price. He's at the counseling center, so I'm going to All right, Mr. Price, there should be a button down there in the left-hand corner that says unmute. If it's like a, there you go. All right. Now, are you Tad Everett Price appearing there from the Counseling Center?
Yes, sir.
All right, there are two cases before the court, 22 CR 174 and 22 CR 234. The matter is set today for sentencing in those two cases. I need two sets. There's two cases. And this hearing is being conducted by Zoom since Mr. Price is at the Counseling Center. His attorney is Catherine Hapner, appearing by Zoom from her office. Appearing on behalf of the state is Assistant Prosecuting Attorney King. The defendant has entered a plea of guilty in each of these cases. In case number 22 CR 174, he pled guilty to count 1, which is aggravated possession of a fentanyl-related compound. In case number 22 CR 234, he entered a plea of guilty to 3 counts: illegal conveyance, aggravated possession of fentanyl-related compound, and aggravated possession of methamphetamine. All right, the court then ordered a pre-sentence investigation report and did allow him to go into treatment. The court has received the report and has reviewed that. Have each of the attorneys had the opportunity to review a summary?
Yes, Your Honor.
All right. Anything from the state regarding sentencing?
Only what is contained in the plea agreement, Your Honor.
Ms. Hapner, on behalf of the defendant.
Thank you, Your Honor. We would ask that Mr. Price be allowed to enter a drug court. He has entered counseling as the first step of that. He has expressed to me on a couple of occasions his desire to get clean and stay clean. And I believe that this would be a good opportunity for him and that he would be successful in drug court.
All right. Mr. Price, anything that you would like to say?
Yeah, I was wondering, is there a chance that I can have a word with Hapner, just briefly?
Oh, yeah, sure. I'm sorry. Okay, I'll go ahead and do that. Put you into a breakout room. I should have said that at the beginning, and I forgot.
All right.
Okay, there should pop up there a button that says join breakout room. Click on that. When you're done, click the button that says leave meeting. You'll have to sign back in.
So click leave?
Yeah, it should say, yeah, it should say click to join meeting, join breakout room.
Something did pop up, but it went that way. Whatever it was.
Don't know where it went.
Something popped up, but it took off to the right.
Huh.
No, there is a leave that's showing.
There's a leave showing?
Yeah, like where you can leave this meeting.
No, you don't want to do that.
Okay.
All right, let me try over again. I've not had that happen. Ms. Hapner's in it, but I'll close it out. All right, Ms. Hapner, they couldn't join for some reason. The button came on and disappeared, so we're going to start again.
Okay.
All right, I'm going to click on open. Then there should be a button comes up that says join breakout.
Nothing popped up.
Well, there's something wrong with your computer because it's working on her end.
Yeah, well, I mean, we don't actually have to go into a breakout. I can speak with her in front of you guys. It doesn't matter. It's just about, where I'm at. Wait a minute, is this it? Well, it disappeared again.
Go down and click on breakout room. There should be a ribbon at the bottom. Click on that and see if it shows where you can join there.
I don't see breakout. Right share screen.
You maybe shrink your screen to get a ribbon there or something. I don't know. Never had this problem before.
This. It's not down there. It's not. We don't see it.
All right. Well, here's an option. Ms. Hapner's back. You can go down to the bottom where there says chat. Can you see that?
Yep.
Click on that, and then there's a place that says to everyone, and click down and go to her name and click her name, and then you type a message to her, and then she can respond to you, and no one else will see it. All right. For the time being, put yourself on mute, and I'll put myself on mute, Ms. Hapner also, and then you guys, as soon as you're done with that, then let me know. This title of this offense, illegal conveyance of drugs of abuse on the grounds of a specified governmental facility, got to be the longest title in the history of criminal cases. I don't know why the hell they couldn't come up with something simpler. All right, and for the record, Ms. Hapner, you and your client are both agreeable to this
Or more interested in me being
Here.
sober.
hearing being...
We're in sober living rather than where section at.
Okay, we can hear you now, Mr. Price.
I'm here.
All right. So for the record, Ms. Hapner, you and your client are both agreeing to this hearing being conducted by Zoom rather than him being required to come back for a personal appearance. Oh. All right, now we're back on the record then. Now, Ms. Hapner, you and your client both in agreement that this hearing can be conducted by Zoom rather than him being brought back for a personal appearance?
Yes.
Yes.
Okay.
Yes.
All right. And are we ready to go forward then?
Yes, we are.
All right. Now, I believe that Mr. Price asked if there was anything that you would like to say regarding sentencing.
Me?
Yes. It's your turn to speak.
Oh, okay, yeah. No, nothing, yeah. I'm content with where I'm at. I'm just looking forward to going to like sober living, transitional. Once I leave here, that's kind of what I ran by her. They wanted me to make sure the court was aware of that.
Aware of what?
Transitional living, sober living, basically.
Yeah, that's part of the plan, I'm sure. Now, Mr. Price, I believe that there's a request, or there was a referral to the drug court docket, and I believe you filled out an application that was filed with the court, it looks like back on January the 10th. Now, the way drug court works is that I sentence people to community control or prison, but I don't sentence them to drug court because drug court is a voluntary program in the sense that people that are on it are in community control and under supervision, but the question is whether you want to get into the program or not, because it's a very intensive program. The program is based on the fact that the persons that are in it are focusing on their sobriety, and that's what we focus on, is sobriety and staying clean, because if they do, then the chances of committing another offense are really, really low. But it has to be voluntary because it's a very intensive program. You're in transition, you're in a treatment facility now. Usually that means you go into a transitional facility after you're done with that, and then sometimes a sober living house, which is a little bit less of supervision and still with other people that are trying to be sober, before you eventually get into your own community, on your own. And if the goal that you have is simply to stay out of prison, then that's really it's not really a program for you, because you're going to have to call in every day once you get out in the community, and while you're in the facility and in transitional, you're subject to drug testing every day. You also be subject to drug testing at probation once you're out of the treatment facility. And so it's extremely intensive. There's a lot of support and a lot of resources that are available that are not available to regular probation people. But I can tell you that with your record, this is your last shot. Because if you don't get sober, you're going to die. Quite honestly, I'm surprised you are still alive with what you've gone through.
Me too.
And so, this is what you're looking at. So, is this what you want to do?
Yeah. Now is the drug court like the only thing that's going to keep me from like say I don't take drug court? Am I going to be pulled out of rehab? Or because one of the things that I'm having down here with is me and my current counselor. I wasn't for sure. We wasn't for sure if I'm in need of all the support.
Your Honor,
I think I can't believe that anybody down there thinks that.
Okay.
I can't imagine that. And if they do, then I need to have a serious talk with them, because with your record, you need every bit of help you can get. Okay. Now, Ms. Hapner, did you want to say something?
Well, I'm going to send him a message right now.
All right. Trying to negotiate. How in the world does he get a 19 on an ORAC?
All right, I think we're ready.
You ought to have 40. That's maximum. All right, now, anything else you'd like to say, Ms. Hapner?
No, Your Honor.
Mr. Price?
No, Your Honor. I'm good.
Right, so the question is, do you want to be in drug court or not?
Yes, absolutely.
Well, you know, I would like you to be in drug court because I think it's your last chance and your only chance to get sober. But I'm a little concerned about what because you're kind of negotiating here. And that's the that's the Tad Price that I've seen for years. Always looking for an angle, always trying to figure out a way to not really do anything more than what it takes to stay out of prison. And then when you get down to your last straw and it breaks, then you go to prison. You know, we've seen that play over and over again in your career, in your life. And you know, as I said, you know, it's time for that to stop. But you know, you're the only one that can do that. And you know, if you're not really serious about this, then you know, because one of the things I'm going to tell you right now, when I tell people in drug court, is that you know, you have to be patient. This is not something that you're going to go in and say, okay, I want to get my 90 days in rehab out and get out and go back home. That's not going to happen. It's going to be as long as it takes. It'll be transitional. It'll be intensive supervision, intensive outpatient treatment, intensive drug testing, probation versus drug court. Then, you know, it makes me worried about you because you've got to be dedicated. And, you know, we know you need the intensive supervision. Your record says that.
Okay. You're right. You're right.
All right. So that's what you want to do?
For sure.
All right. Then it's the order of the court that the defendant's request to be admitted into the drug court be granted in each case. And I sign an entry now to that effect. It's further order of the court that you be sentenced to a term of 3 years of community control under the drug court docket program. And I'm going to go over the conditions generally with you. You've already signed the program acknowledgement, and it's in the file, and you'll be required to sign again when the probation officer will meet with you. But these are generally conditions. First of all, you're to comply with all the requirements that are in the drug court program description and attachments that you received and filed in this case. Be required to obey all laws of all jurisdiction and conduct yourself in a law-abiding manner at all times. You're to report when and as directed and be truthful in all statements you make to the probation department, as well as any answers you give to them when they ask you questions about those conditions. You're to keep them informed of your residence and place of employment at all times. You may not change either of those without prior permission. You're not permitted to leave the state of Ohio at any time without prior written permission. If you do, you have to have that pass with you. You may not enter upon the grounds of any correctional facility or communicate with anyone who's an inmate in those facilities without prior written permission. Because of your convictions, and I think this is already the case for you, but you're prohibited under both federal and state law from possessing, purchasing, owning, or using any firearm, ammunition, or dangerous ordinance, and to do so would be a violation of both federal and state law, which could subject you to being prosecuted. It's a condition you not have any of those or any other weapons of any type while you're on community control and in the drug court. Now, you're not permitted to purchase, possess, use, or have under your control any controlled substance, drug of abuse, CBD oil, with anyone who is a co-defendant in this case or has a criminal record, a member of a gang or any other criminal group, or any person who could in the future or who has in the past influenced you to commit a criminal offense or to violate these conditions, unless that's approved in writing. And that includes any family members that may fall within that definition, unless you were living with them right before this happened, these offenses happened. After the date of this order, you're not permitted to marry or establish cohabitation in a common law marriage type relationship with another person without written permission. You must report any contact with law enforcement or any arrest, citation, or other charge of violating the law or conviction not later than the next business day after that occurs. You must provide your supervising officer financial information records so your ability to pay any fees, costs can be reviewed. If you're referred by the treatment team for any further evaluation or assessment for further training, treatment, therapy, counseling, educational programming, whatever, You're to submit to that, and if they recommend programming, you're to enroll in and follow that and complete it successfully. You're to pay the court cost and make payment arrangements with the clerk to do that. You will comply with your treatment plan as recommended. And so if they say to you that we want you to go into transitional housing, again, they're not the police or custodians. They're at the counseling center. You can leave and go somewhere else. They're not going to hold you back. But if they told you to go to transitional and you didn't, you violated the treatment plan. If you get in transitional and they tell you to go to sober livings, then that's what you do. And again, as I indicated, you're going to have to get permission from the probation department as to where you live, because that'll be part of your recovery, is making sure that they keep you away from the people, places, and things that might be a trigger for your relapse. And you're to comply with any part of the treatment plan that may be recommended by any of the treatment team. Your counselors, therapist, probation department, employment counselors, anybody like that. Now, by being placed on community control rather than being sentenced to prison, you're deemed to have consented to a search without a warrant of your person, residence, vehicles owned by you or used by you, or any other property placed under your control or where you're found at any time by any officer of the probation department. Court will not impose any fine, and there will be no driving suspension. Now, if you fail to make the payments on the court cost, then the clerk could collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then court could order you to do community service and give you credit for each hour you work in an hourly rate set by the court, and each hour you work would reduce your judgment by that amount until paid in full. Now, in the event that the probation department feels that you've not complied with these conditions, they will file a notice of that with the court. There will be a copy given to you. There'll be a hearing. You'll be entitled to have an attorney to represent you at that hearing. If the outcome of the hearing is that you have failed to comply, then at that time the court could revoke your community control. And in case number 22 CR 174, which is a 4th-degree felony, you could be sentenced to prison for a period of between 6 and 18 months and fined $5,000. In 22 CR 234 on count 1, you could get 36 months. Count 2 and 3, you could get 12 months on each, for a total of 24 months, so that's a total of 60 months. And you could be fined $15,000. And all those sentences can be ordered to be served consecutively. So that'd be 60 months plus 18 is 78 months is what you'd be looking at. Now, in the event that you do serve a prison term in these cases, under the law, the Adult Parole Authority, upon completion of that term, could put you under post-release control for a period of up to 2 years. And if they do, you would be supervised on the terms they set. And if during that period of time they find that you have failed to comply, then they can return you to prison to make you serve an additional period beyond that ordered by the court of up to 9 months for a single violation, up to half of your prison term for all violations. But if your violation is a new felony, then in addition to whatever sentence a judge in the new case can impose upon you, that judge is also authorized to sentence you in this case, not in this case, but for committing that new offense while under post-release control in these cases, to an additional period of a year, whatever time's left on that post-release control, whichever is greater. All right, is there anything further from counsel?
No, Your Honor.
All right, now you'll be appearing in court every twice a month, Mr. Price. The next drug court, we just had one last Friday, so the next one will be the 10th of February. How long have you been down at the counseling center?
Almost a month.
All right, they may not bring you back yet. I don't know. They kind of wait to make sure you're settled in before they do, but at some point, either then or maybe the next time, you'll start coming up here with the other people that are in the drug court program to participate in that. And the probation department then will be in touch with you, Mr. Parr. He is a drug court officer. All right, thank you.
Thank you.
He won't last.